This is The Law Show on CL 650. Now back to the show.
Eleanor Rigby picks up the rice in the church where a wedding has been.
And welcome back to the program. Nice to have you with us this early Sunday morning in January for The Law Show here on CIL 650. That was Eleanor Rigby, of course. John Lakes of LakesWhyteLLP talked about Eleanor Rigby cases. What did you mean by that when you made reference specifically to Eleanor Rigby?
Well, Eleanor Rigby in the song was a single person without any relatives.
Right.
And right now, Eleanor Rigby comes in and she's 75 and she says, well, I'd like to name my friend Mary to be my power of attorney.
Okay, sure.
And my executor.
Oh.
But Mary is 79 with health issues. So then you say to Eleanor, well, we better look at somebody younger too. Do you have anybody younger? Does maybe Mary has a good son or daughter that you quite like? Because when you appoint somebody, you have to make sure that they're around to do the duties.
Right.
And as people get older and all their friends get older, they have to look to the next generation. And if they don't have relatives, they may have to look to a financial institution. And the problem with most financial institutions, unless you've got $3 or $4 million,
they don't want to deal with it.
They don't, and there are some smaller ones. So for a lot of estate planning for people to do is they really have to think, first of all, who they wish to appoint, and make sure that that person's available to do the job when they're called upon.
Right.
And as I say, you don't. And with Eleanor Rigby, if she had nobody else, then unfortunately the public guardian trustee would be appointed to look after affairs. And even if you're and the public guardian trustee generally doesn't have any authority to deal with health care issues, mainly legal matters. So again, it's the last thing you want to do is have the government take over your affairs.
Right. So, John White, when it comes to, we're talking about power of attorney on our legal checkup as we enter this new year and step back a little, look at our affairs and how we're going to make it through 2016. And one of the things that we're talking about, of course, the very important notion of the power of attorney. But in addition, people need to think about the other representation agreements, they're called. You give a person the right to represent you in terms of health decisions and so on. John, is it important for the same person to be appointed your power of attorney that will also make your health care decisions and any other representation agreements? Or is I'm trying to figure out who gets the job. Should one person do all of them, or is it better to have one person appointed to each assignment?
Well, it depends on your family circumstances, but your question actually contained a really good point. It's a job. There's responsibility that comes with this. It's perhaps a great honor to be given the ability to make far-reaching decisions on behalf of the person giving you that authority.
Sure.
But there are duties that come along with it.
And you've described in some legal detail exactly what those duties are.
Absolutely. So the question that you might ask is, do I want to give all of these additional duties to the same person who already is my attorney under a power of attorney, or do I want to split those decisions up? With representation agreements, the person who's given authority under such agreement will be dealing with a different area of the donor's life. Mm-hmm. In this case, healthcare decisions rather than business or financial decisions. It may be that there really is only one obvious candidate within the family.
Right, right.
The only responsible person, or perhaps the only person at all, to make such decisions, and in that circumstance, you'd almost certainly name the same person to be your attorney, and also name them in the representation agreement.
Right.
Other families might be different. Maybe there are many people, some who have more time to deal with healthcare issues, and you might have someone appointed under a representation agreement who is not the same person as you've appointed under a power of attorney. It all depends on your circumstances.
Exactly. And John Lakes, typically, again, based on your experience, what's the scenario usually? Do multiple people perform those multiple appointments of power of attorney, etc., or does one person generally shoulder the whole load?
Again, as John says, it depends on the circumstances.
Okay. And does money have a lot to do with it? The more money that is at play would perhaps determine the need for more people involved in the scenario?
Well, one of the scenarios with money is that if money can be dealt with almost anywhere. So, for example, if you live in North Vancouver and you have 3 children, you have a daughter who lives in North Vancouver and a son lives in Kamloops and a son who lives in Merritt, the sons could do the banking because you can do it all online.
Of course, yeah.
Just go to local bank. Well, the daughter is the one who's there. The daughter is the one who's going to be driving her mother to the doctor, making decisions with the doctor. So it's probably not really appropriate unless, if you're going to do a representation agreement, unless it can be only one of, you can have it so only one of 3 need to make the decision, as opposed to they both have to make the decision as well too.
So it's possible, gentlemen, to take any of these agreements, as I understand it, or as I'm coming to understand it, and create, with the capable assistance of a trained lawyer, you can create the circumstances of your power of attorney or of your health care representative, and you can write the terms and conditions under which that person represents you, almost, can't you?
Yes, you can.
Okay.
And one of the terms that's important is there's a concept called the enduring power of attorney. And the enduring power of attorney is the power of attorney that remains in effect if you become incompetent.
Oh, okay.
And you need to specifically say in the power of attorney that it remains in effect if you become incompetent. Because if you don't have that clause, then the power of attorney ceases to be effective upon incompetency.
Being declared, okay.
But it also creates another problem too, because when you do a power of attorney, you can either have the power of attorney effective upon the execution when you actually sign the power of attorney,
or delay it,
or delay it and say it may not be in effect until I become legally incompetent. And that may create a problem, first of all, because you may have something happen that you're fully competent, but you can no longer sign because either you've lost your sight, or else you've had a stroke where mentally you're all there, but you can't sign anything.
Right, right.
Or else you may have circumstances where someone's had a stroke, and the doctors sometimes are reluctant to wait a couple months before they deem that person to be incompetent. So then you can have a gray area that the person's not around to sign anything, and yet the power of attorney cannot actually become effective.
Right.
So I usually say to my clients, and depending on the circumstances, I prefer that the power of attorney becomes valid upon execution, which goes back to
effective today kind of thing, right?
You also rely on the honest person to be there. So usually with a husband and wife, they don't have a problem with that. But it's a real issue as to when the power of attorney is to be effective, upon execution or upon a certain event.
One of the things that one other appointment, as long as we're doing our legal checkup and setting things up for another year of our lives, one of the other, and we've mentioned this person a couple of times, and that is the person who becomes your agent after you die. And is this a good time, as long as you're going to sit down and talk about a power of attorney and your creation of a will, and should that appointment be made, John White, at the same time too?
Well,
the executor.
I would see it as part of the same legal plan that
exactly,
we're talking about, the same legal checkup. The executor is going to take over after the person for whom he or she is the executor dies.
Right.
Upon death, that will be the end of the power of attorney.
Sure.
And so if your attorney under the power of attorney and your executor are different people, then responsibility is going to transfer from the attorney to the executor once there's been a representation grant after death.
Right.
So a prudent plan would consider both what happens while you're still alive and what happens after you pass away.
So do you too recommend frequently to your clients that where appropriate, the same person who has received the bulk of the power of attorney also receive the appointment as executor, John Lakes?
They usually are.
Okay.
But again, every case is unique. Every circumstance is unique. And for example, you might, because sometimes if you have a will and you have 3 kids, you may want to appoint all 3 of them executors because you don't want to hurt their feelings if someone's been excluded.
Boy, and you raised these 3, you should know better.
And
right? But people do that. I know, I've heard that.
Well, but the person, the son who lives in Toronto, isn't the power of attorney.
Right.
And of course, you're always hoping that when you've died, that the son in Toronto decides to resign as executor as well. But it's an important issue because sometimes, and I've dealt with people where they're a bit hurt that their parent has not named them as the executor with their sister and brother, even if they do live in Toronto.
Really?
And then they say, well, at least we could have had an opportunity to resign, but
all those
because you got to remember that a will is still the last message.
That's true.
The world, and so people may read it wrong, and the son in Toronto may say, well, maybe Mom didn't trust me.
Well, I suppose we do have to consider those feelings when we're drawing up these documents. We are talking about the legal checkup, preparing for another year of your life in some kind of organized fashion, with the assistance today of John Lakes and John White from LakesWhyteLLP in North Vancouver, estate planning and wills lawyers, and we'll continue here on The Law Show right after this.
There's more of the show still ahead. This is The Law Show on CL 650.